Damages for breach of contract are a central aspect of contract law and serve as a means of compensating the non-breaching party for the harm they have suffered due to the breach. Here's a more detailed exploration of damages for breach of contract. Types of damages. 1. Compensatory damages. Compensatory damages are the most common type of damages awarded for breach of contract. These damages aim to compensate the non-breaching party for any losses they have suffered as a direct result of the breach. Compensatory damages are intended to put the non-breaching party in the same position they would have been in had the contract been performed as originally agreed. 2. Consequential damages. Consequential damages, also known as special or indirect damages, are damages that arise as a foreseeable consequence of the breach, but are not directly caused by the breach itself. These damages may include lost profits, lost business opportunities, or other financial losses that result from the breach. 3. Liquidated damages. In some contracts, the parties may include a provision specifying the amount of damages to be paid in the event of a breach. These are known as liquidated damages clauses. If the breaching party fails to perform their obligations under the contract, they may be required to pay the specified amount of liquidated damages as agreed upon in the contract. 4. Punitive damages. Punitive damages are rarely awarded in cases of breach of contract and are typically reserved for cases involving egregious conduct, such as fraud or intentional misconduct. Unlike compensatory damages, which aim to compensate the non-breaching party for their losses, punitive damages are intended to punish the breaching party and deter similar conduct in the future. Calculating damages. Calculating damages for breach of contract can be complex and depends on various factors, including the nature and extent of the breach, the specific terms of the contract, and the losses suffered by the non-breaching party. Courts may consider factors such as the cost of rectifying the breach, the amount of lost profits, and any other foreseeable losses incurred as a result of the breach. Mitigation of damages. In cases of breach of contract, the non-breaching party has a duty to mitigate their damages, meaning they must take reasonable steps to minimize the harm caused by the breach. Failure to mitigate damages may limit the amount of compensation the non-breaching party can recover. Damages for breach of contract play a crucial role in contract law, providing a means of compensating the non-breaching party for any losses suffered due to the breach. By understanding the types of damages available and the factors involved in calculating damages, parties can better protect their interests and seek appropriate recourse in the event of a breach.